you want to go ahead and get started? And there are some folks that are still signing in, but we'll let them in.
Yeah.
Okay. Good morning, everyone. Hello. I like all the friendly faces. Good morning, everybody. Welcome to our second class of Get Closed, Get Paid. And I am sharing a screen that we didn't share last time. So today's agenda is we're going to go through some case law updates. Kristen's going to go through some of the recent case law and the proposed settlements that exist that tie into our discussion about buyer-broker agreements. We'll focus on the Florida Realtors form, and I've got the form number there. I'll show it on the screen, but if you have the form in your form packet, you're welcome to take notes on your form. And then we'll talk about buyer-broker agreement enforcement, and also we'll have an open discussion about what any of this means, or what all of this means, and what we can predict for the future of real estate. Now you can see our disclaimer up on the screen. We're saying that this presentation doesn't create an attorney-client relationship, so just take our opinions as to what's going on in the world of real estate, what we're seeing based on our experience and what we are reading. And if you do have any specific questions specific to a particular transaction, speak with your broker, contact an attorney for your specific legal advice. And we do have, especially as to the nature of this conversation, we have a little antitrust violation reminder. So these classes are formed for fostering ideas and open discussion. We are pro-competition. We are not anti-competition. We are not going to anything that will violate antitrust laws. So let's be very careful in our discussion when we're using examples. We are not going to propose a particular form of compensation. Just know that when we discuss examples, we may use X and Y in place of an actual sense of a transaction purchase price. Okay. All of that out of the way, I will throw it over to Kristen, and actually I'm going to stop sharing for now. We do have our agenda. We've got a case law update, and we talked about this. I'm going to stop sharing, and we'll let Kristen take the floor. Kristen, what's been going on in the world?
Yes, welcome everyone. Can everyone hear me? Good. Okay. I just swapped over to my different microphone. So right now, for those of you who maybe aren't aware, real estate brokers nationwide are facing a lot of allegations right now in the form of class action lawsuits, challenging the way commissions are paid to real estate brokers. And it's a nationwide thing. There are 4 class actions at the moment. Those class actions are by the name of Seitzer, Merle, Nosack, and Leader. All 4 class action lawsuits challenges are based in antitrust. So antitrust claims generally that the participants in the market, those being brokers, NAR is also a member of some of these, or is a defendant in some of these lawsuits, and also some individual MLS organizations are defendants in these lawsuits. Are working together to set prices for commissions and artificially inflate the commissions that are due to 6%. 3 of the lawsuits are brought by a class, and a class, for those of you who don't know, is a class action lawsuit. Think of it like what you see on TV where they say, were you impacted by an environmental hazard or something like that. Like, it's where a group of claimants who are similarly situated, meaning they've all kind of been damaged the same way by the same type of action, come together and sue as a group. Instead of suing one at a time, the whole group sues together on behalf of one claimant. So one claimant's named, but it's on behalf of the entire class of claimants. And there's 4 of them going right now. 3 are groups of primarily sellers. So they were past sellers of real estate who paid commissions to real estate brokers. And then there's 1 group of buyers, but all of them are grounded in antitrust. All of them are claims related to claims that brokers are working together to set the commission prices. And there's challenges. Those challenges get really complex, but they also relate to how NAR rules dictate cooperating commission and how that's offered on the MLS. NAR is a defendant in some of these lawsuits. The other things you should know about these lawsuits is that the Department of Justice has intervened. If anyone might recall, a few years ago, DOJ kind of looked at how the practice of real estate commissions and industry, and had set some guidance on how clear cooperation should be dictated. And some of the rules that came out of that was the transparency policy, which I believe went into effect about a year ago, 2 years ago. Erin, I'm not sure if you remember the exact date, but the transparency policy was supposed to just help make it more clear to consumers when there's a cooperating commission paid by a seller, how much that is and how much the buyer's agent is being paid. So that clear cooperation and the transparency rules that changed was part of the first DOJ investigation. DOJ is looking at it again. DOJ has intervened in some of these lawsuits and said we're not, not a party to the lawsuit, but we're interested in what's going on here and we want to make some statements. So there's a lot of interest in this topic. There's a lot of interest in scrutiny right now as to how commissions are collected, who pays the commissions, and how that is communicated between parties to the lawsuit. The first class action is set to go to trial on Monday, so this is very timely. Jury selection starts this Friday, the lawsuit starts next Monday, and the trial is supposed to go for 3 weeks. So 3 weeks from now, hopefully we will have a much better outlook on where all of these claims are going. In the meantime, two different very large, there's been a few settlements, but two notable settlements you should know about came out of RE/MAX and Anywhere Real Estate, which are two huge brokers. Anywhere covers a variety of brokers, I believe Better Homes and Gardens, Century 21. And so the settlements have already been proposed by those parties to the lawsuit. So those defendants have already said, we'd like to settle and here are the terms. Those settlements have not been approved by the court. That's going to take several months because these settlements don't just get settled. The court has to actually look at them and approve. But those settlements are very important. So right now what those settlements say, like I said, we're not sure if they're going to be approved, is that these brokerages are agreeing to pay a lot of money in damages, in the millions. Anywhere settlement is around 83 million and RE/MAX's is around 55. But they're also agreeing to practice changes in their industry. Those practice changes, two that I think are most relevant to everyone here, is that $0 in commission. They're not going to require any commission to be paid to buyer's agent. So, which means that they're going to offer cooperating commission at $0. So if you represent buyers in transactions, that means that cooperating commission that you rely on in a transaction, the offer of compensation on the MLS could potentially be going away, or could be potentially not offered as frequently because it's not going to be required. The second change, and it never was required, I just want to make sure we're clear on that. Right now, the MLS requires $1 if you enter it on the MLS. So this change is really only $1 to $0. And a seller never had to join the MLS, but this is just going to dictate that even clearer that $0 can be offered and the compensation doesn't have to be offered to buyer's agents. The second change is that these national brokers are not going to require everyone in their companies, their franchisees, their agents, all that, to join NAR. So those are the two big things that I see changing, is that there's going to be less of a requirement to participate in NAR or join NAR, at least from a policy level. As a practical matter, people may still join NAR at the same frequency, but there's going to be less from a policy level of people agents being required to join. And then the second change is that commission might not be offered to buyer's agents. We had selected to do buyer broker agreements in October before this really came about. We've been watching this for several years. These lawsuits have been in the works, but it all kind of heated up and these settlements came out just in the last couple of weeks, well before we set the schedule for Get Closed, Get Paid back in the summertime. So it ended up being a timely topic. There was a moment where we thought maybe we should do this in November, but we decided to stick with October because the settlements are out. We do have that information. Yes, it's pending approval. Yes, the lawsuit's still pending, but worst case scenario, we'll do a follow-up in November once we have more information. But right now, what's important to you to take away is that if you represent a lot of buyers and you rely on that cooperating commission that's typically paid by a seller, you've got to understand that might not be a guarantee commission. And in those circumstances, how will you get paid? If you're not going to be paid by the seller, you're not going to be paid by the listing broker, how are you going to be paid? And the answer to that, I think, and I'm not an industry expert, I would say, like there's a lot of people trying to figure this out at the moment, is that you're going to be paid by your buyer. And you have to really justify how you work and what value you bring to a transaction to make sure that you get paid. I don't know how many of you guys use buyer brokers. If you do and you're on camera, raise your hand. I enforce buyer brokers all the time, and I have been for several years. And there's challenges to enforcing them, which is what I'm going to get into later. But right now, I think it's important that you guys understand what the buyer broker agreement is, what it does, and how to sell it to your customers, that you're under contract with them and their buyer has committed to paying you the commission in case you run into a situation where you're making an offer on a property where no commission is being offered anymore. So with that, did I forget anything in my very brief summary of the massive changes going on in the industry?
I don't think so. I think a couple points you touched on are really important, that you're right. MLSs will determine the amount of minimum compensation offered to a cooperating broker, and that going from $1 in many jurisdictions or penny in other jurisdictions to $0 may or may not have an impact on how a seller, or if a seller is willing to offer a cooperating broker compensation, right? So it may, and I think the fact that there are these class action lawsuits, I mean, sellers are paying attention, right? Sellers are going to be paying attention to the news, and that they see that, hey, how compensation has traditionally been offered may be changing. They may be more willing to have those conversations and negotiating conversations with the listing agents. And also buyers as well need to understand the value that buyer's agents bring. And so, Kristen, you've been teaching these buyer broker agreements classes well before the lawsuits. And so you've been explaining to agents how to use them and also how to enforce them to make sure that you're getting paid. What is the biggest challenge you've had in talking to real estate agents about using the buyer broker agreements? And we'll get into the details of the buyer broker agreements in a minute, but what is the biggest challenge, and what do agents say? I'm afraid to ask my client.
So I would say in two buckets, the answers come. One is I don't need it, which I think historically was individuals relying on the fact that they provided really good, excellent, customer service, and my customers won't cheat, and I will always get the deal done, and it's not needed. And I think there's a lot of validity to that. But I will also tell you that I have enforced buyer broker agreements in situations that are very egregious. And what I mean by that is situations where the buyer's agent went so far above and beyond for their customers, and they were still circumvented because somebody offered a rebate then commission. A cousin said they'll put the offer in their name. I mean, and I say that because you don't know that it's going to happen until it happens. So I think the one camp was, I don't need it because I provide really good customer service, and that's never going to happen to me. My customers aren't going to cheat on me. The second answer I get is, I don't think my customers will agree to this. For that camp, what I always like to say is, you start to expend time on your customers the minute they call you. I mean, the minute a prospective buyer calls you, you're stopping what you're doing, you're taking the phone call, you're trying to figure out what type of house they want, where they're looking, is it something you can even help with? And then, from that minute, you're spending valuable time. The minute you get on the MLS and set them up on a drip campaign or start looking for properties for them, time. The minute you put them in, meet them at a property to do a showing, time. And you're doing all of that without any guarantee that you're actually going to be paid, because there's no agreement with them. Under the current rules and the ethics rules, and I get a lot of calls on this on procuring cause, is I think I have a procuring cause claim. And the first thing I ask is, do you have a buyer broker agreement? And they'll say no. And I said, under the rules, really, and procuring cause, just to clarify, is a concept under NAR rules of ethics, and the arbitration rules under NAR. They define procuring cause, and they have a way to define that. But procuring cause as a legal concept is also well established in Florida case law. In both of those scenarios, a buyer has the right to fire you at any time, absent a contract that says they can't. So in situations where you go with one broker or a buyer goes with one broker, looks at the property, says they like it, and then decides I'm going to call my cousin to put the offer in because they'll credit the commission for me. In that scenario, it's going to be really hard to prove procuring cause in certain circumstances because showing the property alone is not always enough to prove that you've got procuring cause. They could say, I fired them because I didn't like them. I didn't think they were going to get the deal. There's a whole variety of reasons buyers will say they didn't decide to go with that agent. So that's the kind of the second camp. The second camp is I don't think the buyer will agree to this. And my answer is, that was a long way to get to my answer here, but my answer would be, I have to spend my time on you the minute you call me, and I need a guarantee that we're going to be paid. And also that you still don't have a guarantee to be paid because if they never buy anything, you're not going to owe. So that was a long one.
But that is very helpful, Kristen, because that sets up some of the objections that we're going to go through on this buyer broker agreement that explains that maybe a buyer doesn't want to be stuck in an agreement with an agent for a very long period of time. Well, you can set the term of your buyer broker agreement. You may be looking at particular geographic region with this agent, and maybe you're looking up at the Panhandle and you want to look at other properties with another agent. Maybe you want to set sort of the geographic restrictions for your time. But also, we both work in the legal field. We have engagement letters that we send to our clients most of the time prior to commencing any work on a transaction, right, or any work for a buyer. So we have to explain our value for your, for our fee. These are the things that you can expect from me. These are the things that I will do. These are the things that I expect you as my client to do and to perform. So I think it's certainly not. The concept is not unheard of, right? So if a client goes to a doctor, they are going to be paying a fee for services. So the real challenge, I think, is getting the client to understand what exactly it is that a buyer's agent does. And if you as a buyer's agent can't say what you do, then you're gonna have a really hard time convincing a buyer to pay you for your services, right? No matter where, no matter where the fee comes from. So I'm gonna share my screen here. I have the, give me a second. I have the exclusive buyer broker agreement. It is a Florida Realtors form. The one that I chose is the one that ends up in a transaction broker relationship. So this is a form. It is for educational purposes only. The reason we're showing you on the screen, of course, is that we can kind of follow along and understand what the terms of an exclusive buyer brokerage agreement looks like. There are plenty that are offered through local boards. Even brokers have their own forms. Naples Area Board of Realtors, for example, has its own separate form, a little bit different, and I can kind of highlight some of those differences. But essentially, this is, I like to call it a prenup for real estate. It's probably a terrible term, but it sets out the parties' expectations and who gets paid what, and assuming the transaction closes. Okay, so we have our parties. Of course, this is between a buyer and a broker. Not agent, but broker, right? Brokers are the ones who are binding an authorized party on behalf of the broker, is one who can sign a broker agreement, similar to a listing agreement, right? Or in very limited circumstances, would a real estate agent, licensee, be authorized to bind a brokerage unless they have a specific authorization agreement. So it's between the buyer and the broker. And so we're in paragraph 2, we're talking about the term of the agreement. So again, you can set the term of your agreement. Let's say you have a client who's coming in town for 2 weeks and you're not sure if you want to work with them. They're not sure if they want to work with you for an extended period of time. So then you can set the term of your agreement for a few weeks that you're going to be providing these services. And during that time period, if the buyer enters into agreement to acquire property, then this can, so essentially you're going to get compensated for your work that happened during that time. Again, assuming it culminates in a sales contract. When I talked about the geographic restrictions, the enable contract does not have this geographic parameters. It actually says the enable agreement says if the buyer enters into a contract at any point during the term of the buyer broker agreement that the broker is going to get compensated. This is a little bit different. You can just define the type of property that the buyer is looking for, the location, the price range, if the buyer has or has not been pre-qualified or pre-approved, and then of course the preferred terms and conditions. This is really helpful for you also as an agent when you're going and setting up your searches for your client to identify what it is that you're looking for your buyer. And of course, if you find something that fits those parameters, that you will be compensated. My favorite paragraphs, of course, are the broker's obligations and the buyer's obligations. So this is the bare minimum that you're saying, I will do these things on your behalf. My broker, I licensee broker, will do these things for you, agent. But I know what you guys do. I mean, if we listed all of the things that buyers agents do on behalf of their clients, it would be a couple of pages long. So we're going to talk about that in the chat in just a minute. But essentially, brokers saying, I will do, I will use my knowledge of the area. I will use my knowledge of the sales contracts. I'm going to help you work with you and your lender to figure out your ability to purchase a property. I'm going to, locate and view suitable properties for you. I'll preview properties for you. I'm going to assist you in preparing the sales contract, monitor your deadlines through closing. I'm going to assist you with the inspections. Right. We're going to, of course, cooperate with the seller, the listing agent. And this is really important key. It says that the buyer understands that even if broker is compensated by a seller or a real estate licensee who's working with the seller, so the listing agent, the compensation doesn't compromise the broker's duty to the buyer, right? The buyer's broker is still obligated to perform on behalf of the buyer. And that is the bare minimum. So that is not a scary thing that, a buyer should be afraid of, right? These are the things that are bare minimum that I will do, but I as agent of ABC brokerage, I hope ABC is not an actual brokerage, on behalf of ABC brokerage, these are the things that I do. This is why you should choose me. This is why if we connect and we want to work together for 1 month, 3 months, 6 months, these are the things that you can expect from me. But also, it lets the buyer know in subparagraph B that you as an agent could also work with other buyers. You could also present other offers to a seller on behalf of other buyers. So you can't disclose the material terms of the other offers, but you may, while you're working with buyer A under this buyer broker agreement, you may also work with buyer B and submit offers for the same property. So let the buyer A know. Of course, we are going to all comply with the rules in fair housing. We're not going to discriminate. Subparagraph D is a little CYA. We're not warranting vendors' quality of service, and that's broker's obligations. Again, I would suggest verbally or by email or by a beautiful flyer supplement what exactly it is that you and your brokerage will do on behalf of a buyer. This is the contractual agreement, but please explain to your client why they should work with you. All right, but also it says, hey, buyer, this is what I expect from you. I expect cooperation throughout the transaction. Please don't ghost me, right? Let's keep it the open lines of communication. I'm going to provide my broker with actual accurate personal financial information regarding my ability to acquire real property. So if the agent asks for proof of funds, for example, or a pre-approval letter, the buyer is going to agree to provide that. The buyer is saying, I will be available to meet you with a reasonable time for a consultation. If I was sub D, I'd be a little concerned about that. But we're going to say we're indemnifying the broker and holding them harmless for any losses that are incurred because of the broker acting on the buyer's behalf. We're asking our buyers to say they're not going to ask the broker to violate fair housing. And of course, I love F. Kristen and I both love F, that a buyer is going to consult with the appropriate professionals for legal tax advice. So remember, our real estate agents are not going to practice law without a license, saying that they're going to consult the appropriate professionals, and you as the agent are going to direct them, provide referrals for those services. So we've set out what the broker is obligated to do under this agreement and what the buyer is obligated to do. Again, this is all very bare minimum. Thanks, Kristen. Bare minimum relationships. But again, you on behalf of your brokerage, you know what you do. You know the lengths that you will go on behalf of your client to get a transaction put together and get a transaction closed. Now, there is an optional retainer provision. So some folks could use this retainer provision that says, upon execution of this agreement, the buyer will pay to the broker a non-refundable retainer fee, and you can select to have that retainer fee credited to the buyer if compensation earned is essentially if they culminate in a transaction that results in the buyer broker compensation being paid. I've not heard of anyone using the retainer provision, but you could. So if you're worried about spending a lot of excess time with a purchaser and you're not quite sure whether they're going to be a real buyer moving forward, and you block out a whole weekend on behalf of a buyer, perhaps you could request them to retain you because your time is worth money, your gas is expensive. Again, I haven't seen a retainer being used, but there is that option. Okay, so how do we get paid under the buyer broker agreement? So we're saying that it's earned when the buyer contracts to acquire real property as specified in this agreement, and the buyer will be responsible for paying the broker the amount specified plus any taxes, but will be credited any amount which the broker receives from a seller or a real estate licensee who is working with the seller. What does that mean? So let's say under sub 7A that my fee as a buyer's agent is X. I'm saying X right here. If my fee is X, and the listing broker is offering Y as cooperating compensation, and that is less than I'm due under my buyer broker agreement, then the buyer would be making up the difference. Make sense? If my compensation is Y and the listing broker is offering X, which is more than the buyer's agreeing to here under the buyer broker agreement, then buyer's not paying anything above and beyond, and the agent gets to keep the difference, anything over. So essentially, between you and your buyer, you're setting the fee for your services. You are saying my time is worth X. This is what what my time is worth. For me to work with you for X period of time, this is what I expect to be paid at the end. I can't tell you what you should be. I can't tell you what you should be paid. That is all up for negotiation between buyer and the broker, just as listing broker compensation is between the listing broker and the seller. So let's see. Okay, 7E, buyer default. So the buyer is going to pay the broker's compensation immediately upon buyer's default on any contract to acquire property. So if you're with us last month, we talked about default. The default doesn't mean a buyer's ability to terminate their contract and receive a return of their deposit. A default is a default. A buyer refuses to move forward through closing. They don't have a right to terminate the contract. They just default, fail to move forward. Okay, so we also have a protection period similar to our listing agreement. We have a protection period where the buyer will agree to pay the broker's compensation if within X days after the termination date, they contract to acquire any property brought to buyer's attention by broker or found by buyer. So for sale by owner, found by buyer, if the broker sent the listing during the term of the agreement, unless buyer enters into a good faith exclusive buyer brokerage agreement with another broker after the termination date. So again, we've got the termination date, we've got a protection period. So if the buyer enters into a contract after the termination date for any property that the broker introduced to the buyer or the buyer found on their own, provided that the buyer is not entering into another exclusive buyer broker agreement with another agent, then compensation would be due under this agreement. And then we've got the early termination clause. So this is very interesting. This does not appear in the Naples Area Board of Realtors agreement, but buyer could terminate this agreement at any time by providing written notice to the broker. So buyer can say, you know what, we're just not working out. This is relationship, buyer broker relationship is not working out. I'd like to terminate, but the broker would still be compensated if the buyer enters into a contract for any of the properties prior to the termination date. The broker can also terminate this agreement by written notice to the buyer, and of course the buyer is released from all further obligations under this agreement, which is kind of great. It's a neat little buyer's escape clause, or a broker's escape clause. Again, if the relationship's not working out, there's no sense in both parties being miserable. That either party could terminate. But of course, if the buyer enters into a contract and they just don't want to work with the buyer's agent anymore, they can terminate, but they're still going to owe the compensation to the broker if they entered into a contract prior to termination.
Oh, we do have a question on that, so I don't know. Do you mind if we do the question now? Okay, just because I saw it come in the chat, and I know you're focused, so I just wanted to let you know. So there was a question of how is there an agreement that further protects the agent? There's different forms of the buyer broker. This is the Florida Realtors one. The Florida Realtors has an out for the buyers to walk and terminate the agreement. You're protected for anything that you already showed, but if you hadn't shown them yet, then that's going to be an issue. Where a situation where I don't like this agreement for realtors is, for example, if everybody remembers not too far ago, unless you're a brand new agent, when there was bidding wars happening and things like that, it could take you months to get an offer through for a buyer, and that was just normal. You could submit offer after offer after offer, and buyers were getting frustrated and saying, you're not getting it done, I'm going to go find someone else. In that situation, you want someone, I think you want the buyers under a term contract, because it's just the nature of what's happening, and you want to lock them in, because it's going to take a few tries. If anyone was around then, you know, it took a few tries sometimes to get offers through. Maybe more than a few, I'd say. Some that were, 15, everybody knows that. But if you want them to be locked in for a certain amount of time, say 3 months, 4 months, give me at least 4 months to try to find your property, then you may want to add language to the additional terms and strike that language and set it for a term. That's always something I would recommend you do with counsel, or at a minimum with your broker. And not something that you just do on your own to make sure you get that language right, but that might be something you want to consider. And then when Erin shows you the other contracts, you'll see that. But there are other contracts that have it for a term, and it's not cancelable, cannot be canceled at any time. And I don't work for Florida Realtors, so I can't tell you why they have this in the form, but this is the form that they have. So Kristen, so you're answering the question, is there an agreement to further protect the agent? So the one solution would be to work with the broker and have paragraph 9 in its entirety regarding early termination stricken from the contract. So is that what you're saying? I wouldn't even say the entire thing. This is where the lawyering comes in, but if that's a term that you want different in your contract, and that's something I would say to speak with your broker, and maybe the broker's counsel to work on coming up with an actual term versus an early termination and making that adjustment. If you're going to work with this form, or you're going to have to work with another form, which there are other options. At least NABAR has their own form. I don't know if NEFAR has a form. I'd have to check the other boards, but I know Naples has a few options, and I like them all personally. But carry on.
So, but also, I would also imagine that once sort of we know which direction folks will be going post lawsuits, I imagine brokers will be hiring counsel to draft their own brokerage type form, right? To make sure that whatever terms that they as a brokerage decide that they would like to include. And perhaps also would be an opportunity to flesh out what special things a broker would be doing on behalf of a buyer, in addition to sort of the bare minimum that's listed here in the Florida Realtors. If there's something special that your brokerage does that other agents are not offering, that's an opportunity to have sort of a custom form.
Yep, and I have clients that have done this for, I have clients that have just asked me to provide a paragraph to change the language of the standard form, and I have clients that have their own standard agreement. So it really depends on what you want for your brokerage.
So we'll talk about dispute resolution, Kristen, in a little bit, but essentially we have a mediation requirement, and then if settlement's not reached in mediation, then the Florida Realtors form requires binding arbitration. What I find interesting about this paragraph 11 regarding assignment is that the broker can assign this agreement to another broker. I would imagine the same applies if the agent wants to assign the agreement, right? Agent/broker wants to assign it to someone else within their brokerage, and they're like, I'm not connecting with this particular buyer. I'd like to leave it open for my brokerage, someone else in my brokerage to handle this buyer. That's certainly an opportunity, and the agreement inures to the buyer's heirs and personal representatives, which is also very interesting. Nothing wrong with it. Just, I think it's very interesting that an agreement for a buyer to purchase real property inures to the buyer's heirs, which I think is, anyway. So one of the issues that Kristen mentioned when she's talking about the case law was the sort of the lack of transparency, the lack of explanation of the parties, the agent's responsibilities to the client, or not really being clear about the kind of relationship. So this particular form we're talking about, it's very clear that the broker will act as a transaction broker, and it lists all the broker's duties to the buyer as the transaction broker relationship. There is plenty of opportunity to include special clauses. I will caution you from the unlicensed practice of law. Please, if you're going to include special clauses, make sure that you have at least your broker, perhaps broker's counsel, review those clauses, include them. And this will be signed again by the buyers, by the real estate associate, and also by the broker. And we talked at the very beginning that the broker is the person who's authorized to bind the brokerage to any contract. Now, I don't have the neighbor form pulled up just yet, but Kristen, do you want to jump into, if we have any questions, we can go into questions, and then we can jump into how the heck do we enforce these agreements?
Yeah, so I'll get into enforcement while she pulls the neighbor form up. Enforcing buyer brokers is not the easiest, especially in a situation of circumvention, because you don't always know they've purchased until they've purchased. So this is an example, especially in a circumvention situation where you are working with the buyer kind of ghosts you, you don't know what happened. You usually have that gut feeling that they did something or went and bought with someone else, and then they do. And there's always a question of, how do you find out? I've had clients that have found out in a variety of ways. Some by complete mistake, in situations where, say, a buyer was working with a certain mortgage lender and an agent, the buyer decides to work with another agent, real estate agent, but kept the same lender. The lender didn't know the agent changed, and they notify the old agent. I've seen that happen. Facebook. All buyers post their new house on Facebook, and they usually become friends with their agent somewhere along the way. So they post the picture, I bought 123 Main Street, and the agent's like, wait a second, I showed them 123 Main Street. And I did not get a commission check. In those circumstances, that's kind of how it comes about. I mean, typically what you know when you're going through this transaction in the case of a circumvention situation is that the buyer has stopped working with you or communicating with you. That will be your first indication. And then from there, it's going to depend on whether they enforced it. I have customers who in that situation, or sorry, I should say I have broker clients in that situation who know something's going on, and they'll just check public records and see if they bought something. And lo and behold, I usually say that for folks who have a kind of a gut instinct, they're usually right. There's usually some sort of circumvention. The challenge with that is the way to recover. You can do a demand letter. I find a lot of buyers don't respond to the demand letter, in which case you've got to go to litigation or follow whatever all of the other dispute resolution clauses in your buyer broker agreement, and that can be challenging. In situations where you know the buyer has circumvented you, or in situations where you're representing the buyer and you just need to collect a different commission, that's a situation where you might be able to intervene prior to the closing and try to get it resolved prior to closing and get the actual payment issued at the closing table. I do find that in the situations of circumvention, the title companies are not always going to honor your commission, and they'll say you need to deal with it after closing, in which case you file suit after closing. But it's all going to depend on the specific facts of the case. I know we kind of discussed this in our last Get Closed, Get Paid. Commission disputes in general always involve some sort of commission agreement between broker and customer and the underlying transaction, which is buyer seller, and those kind of go hand in hand, which make them really fact specific. So there's always got to be a review by legal counsel to figure out what can happen. You know, unfortunately, you're getting taught by lawyers, so we're just going to say that over and over. But just work with us. Okay.
So Melissa's question. So does the buyer pay on the closing day through the closing statement? So yes.
Ideally.
Yeah.
So ideally, it's going to be dependent now, buyer brokers are not as enforced as regularly as I suspect they will be if all these changes happen because of the commission lawsuits. So that is going to be a change. I think that's going to be a change. It's something that Erin and I sit on a committee with a bunch of lawyers that we're discussing next month in Tampa. We have a meeting next month, and this is one of the things we're going to talk about is how does this impact the closing agents? Because right now it doesn't come up enough, I think, for there to be a general practice of how you acknowledge these agreements. Now, what you can look towards for guidance, I think as an industry we can look towards for guidance is how buyers agents get paid in commercial transactions, because in those circumstances that how commission gets paid in a commercial transaction is all over the place. For anyone who does commercial, it could be paid by the seller, it could be paid by the buyer's agent, it could be paid, you know, if the commission could start at a 4%, end up at 1.5%. It's all over the place because it's heavily negotiated in the transaction. So I think we kind of have to look at that and figure out how that's going to translate into the residential world if the MLS offer of compensation isn't something that can be relied on anymore to determine the buyer commission.
Yes. So Melissa, in a perfect world, I would send, as a closing agent, I would send out the commission verification forms to the listing agent and to the buyer's agent, and they would return those. We have electronic forms. So they would return the electronic forms to me and say they were due X number of dollars, Y number of dollars, and we put the commission amount on the settlement statement. We don't always ask, where did this come from? Like, we don't always say, okay, is this commission that you're due from the buyer or from the seller? Is this pursuant to a buyer broker agreement? I think we're going to start asking those questions. Right now, the assumption is that both commissions will come from the seller side unless we receive a buyer broker agreement, right? Unless we receive something else from the customers. But right now, we send out commission verification forms to the listing broker. Listing broker will tell us what the total compensation is, the total commission that will come from currently from the seller side of the transaction, and the buyer's agent is going to tell us of that total compensation that's coming from the seller side and what is it exactly that they're due. And if they don't add up, if they don't meet, we're going to ask further questions, right? But as we discussed when we were going over the buyer broker agreement, the FAR form, that if your buyer broker agreement says you get paid X and X is less than the seller's compensation is that it's offered, then of course you would be compensated completely from the listing broker side of the transaction. That was a confusing statement, but I hope that was clear. I imagine, again, as a closing agent, we're going to be changing our forms. We might add a column to our commission verification form to say, okay, who exactly is paying this? And also, of course, you guys have your transaction fees, right? So your broker might require transaction fees. So we say, who's paying this transaction fee? Is it the buyer side who's paying it, or the seller side who's paying it? Actually, I have to make a note. We're going to change our commission verification to double soon. Okay, so we do have the NABOR form. I'm going to go ahead and share my screen. So this is the Naples Area Board of Realtors buyer broker exclusive agreement. It is similar in concept, explains the broker's role. Again, this is the bare minimum that a broker is going to be doing on behalf of a party to a transaction. It also describes the broker relationship. So you've got to insert, it's not going to presume the transaction broker. You're going to insert your buyer broker relationship here. It's likely going to be a transaction broker. If it's left blank, the default is a transaction broker relationship. it's explaining the buyer's role, what the buyer's agreeing to do during the transaction. They're working exclusively with the broker during the term of the agreement and be available to evaluate the properties. Refer to the broker all inquiries in any form of any source regarding any potential properties for sale or lease. Buyers, of course, are going to provide their financial information necessary for the performance of the agreement. They're going to provide the broker general information about the kind of property that they're looking for. And of course, on all occasions, I love this one, on all occasions, notify other brokers and third parties of the existence of this agreement and the broker's exclusive relationship with the buyer. So this puts the buyer on notice that they should be notifying, during the term of this agreement, they should be notifying the developers that they're going to, if they go to an open house and someone says, are you working with an agent? The buyer's obligated to say, yes, I have a buyer broker agreement, I'm working with an agent. This, again, we talked about this not having sort of a geographic restriction built into the terms. It just has a term of the agreement. So the term is, well, default is 180 days, similar to our the neighborhood listing agreement. If buyer enters into a contract to purchase prior to the termination date, the agreement is automatically extended until the closing of that contract. If during the blank day period, so you can include your sort of protection period after the termination date, if the buyer enters into a contract for property that was identified during the term of the agreement, then of course the buyer is going to pay the broker's compensation and the agreement is extended. Again, all very for us in the neighbor land and the neighbor listing agreement, very familiar terms for us. Now, broker's compensation, paragraph 5, this is an opportunity for us to share, explain to the buyer what our compensation is, what our fee is for our services, whether it's a percentage of the purchase price and transaction broker fee, for example, or a flat fee. Do you want to, Kristen, do you want to talk about the default provisions here? So we're assuming the buyer is going to pay the compensation at closing upon the closing of any transaction.
Yeah.
And
so
yes.
Yeah. So the default language in this contract, which I don't know that this is necessarily enforceable, but this derives lien rights in Chapter 475. You as a broker cannot place liens on properties, whether it's a listing or a broker or a buyer. You can't place liens on properties without violating Chapter 475, your license, what governs your license, your real estate license, unless you have an agreement in writing with the customer that says you are going to exercise lien rights. So as a practical matter, you can't place a lien on something you don't own yet. So when the buyer signs this agreement, they don't actually have anything to lien because they haven't purchased anything yet. But as a broker, you're going to be in a situation where you're not going to be able to do liens if you haven't actually authorized it with the customer in a written agreement, because that puts you in hot water with Chapter 475, DBPR, FREC, and you don't want to be in that situation. So that's why you have that language in this agreement. That's language I put when I make custom buyer broker agreements. But as a practical matter, don't let that think that you can lien property right away. There are situations, there's a different commercial lien disclosure act in Chapter 475, but that's broader and it applies to proceeds under the sale and you've got more rights. In residential world, you're going to have, that commercial lien law doesn't apply. So you want to have the rights to do liens, but know that you're not going to have an automatic lien. Usually in this circumstances, you won't have a lien on property unless you get a judgment from a court. Does that answer the question?
And so, yes, thank you. So when we're talking about this, I'm going to discourage you from trying to lien a property that a buyer is under contract for to try to get paid. Don't do that.
Yeah, I mean, I don't think it's easy to lien property even under a listing agreement because everything is fact specific. It's not like, boom, you get a lien. That's not how that's not how it works.
Yes. Okay, so we have the similar hold harmless language, fair housing language, attorney fees and costs. So this agreement has the prevailing party attorney fees similar to our sales contracts or listing agreements in NABOR, that in connection, paragraph 9, in connection with any litigation concerning this agreement, the prevailing party shall be entitled to recover reasonable attorney's fees and court costs and like this from the non-prevailing party at trial and appellate levels. Makes sense.
I like that.
And
I like
it
that. That's
includes
different from Florida Realtors too.
yeah, but it also, similar to the sales contract, it requires folks to think long and hard and think about the facts and circumstances of their case to determine whether it makes sense for them to move forward or not. Folks fighting on principle can get very expensive, especially if they don't have a strong case. And then the cooperating broker disclosure, it says it's required by National Association of Realtors. The broker's policy is to cooperate with other real estate brokers in the marketplace to the fullest extent possible, regardless of the broker relationship, and provided that such cooperation is in accordance with instructions from the buyer, cooperate with other agents. You've got a provision where you can add other terms and conditions. I think this is an interesting location for this little disclosure, but it's an important little disclosure that video and audio surveillance with recording capability could be used in any property that's used by a buyer, so make sure that you're not having private conversations in the properties. Again, signed by the buyers, has contact information for the buyers, and also signed by the authorized broker and has the brokerage information. Kristen, so you have included some of these terms into some of your agreements. What is it that you like about the neighbor form? The default provision?
So I like, yeah, the default. So what I like from someone who enforces these agreements is attorney fees, the right to litigate, not the requirement to mediate and arbitrate first. And the term of the agreement not being, the term actually being defined as a good chunk of time to actually get these transactions done. And I like that because I think that there's a lot of situations where buyers get impatient, and it's not because the service wasn't provided properly by the broker, it's just the market that they're dealing with. And I think that that time frame helps all the parties stay in contract and get things worked out. The second thing I like about this contract, which is something you can do with the Florida Realtors contract, is that I like having the geographic scope defined as broadly as possible. And I say that because for anyone who has worked with an out-of-state buyer, sometimes they say, I want to buy in Miami, and they really mean West Palm to Miami. This just like, there's like this weird, like, I want to move to Orlando, and then it ends up being they want to move to, you know, Osceola County, not Orange County. Because especially with out of state, and it happens not out of state too, but and you got to think, like, if you're willing to go, if you live in Broward and you're willing to go up to all the way to, you know, Indian River County, then you want to define it as broad as you want to go. And sometimes I say even define it broader, because if you've got agents that you work with in other areas, what's to stop you guys from doing it as a co-broker situation? Yeah, you might not be local and be able to do the showings. Maybe that's a pain in the butt. You don't want to do that, but you're happy to write the offer still. So I say always define your scope as broad as possible, because you can always change it. You can always bring it back down if it's a situation you don't want to work with. And then the other thing I say is, if your buyer magically wins the lotto and their $500,000 budget goes up to $5 million, would you go to Tallahassee and do the deal? Maybe you would. I don't know. So broad geographic scope and a term, and then attorney's fees is a legal concept that's, you know, you got to take that on a case by case basis, but from an enforcement standpoint, I find it's easier.
Thank you. Thank you. Okay, so there's one other agreement the Naples Area Board of Realtors has that is a very simple one-page form. I've seen it used with for sale by owner transactions. So, you know, a buyer says, listen, I want to buy my neighbor's property. I want you to help me through the process. I've identified the property, but I'm willing to pay you something for your time. So this buyer agreement for broker compensation is an opportunity for a buyer and a broker to agree that at the closing of any property, you know, buyer's going to pay X dollars. Great. Kristen, you like that? Pretty straightforward.
Yep. This is a good form. This is a great form for your one shows and things like that.
Yeah. Oh. All right. I'm going to stop sharing and then see if we have any questions in the chat. If you registered through Eventbrite, then we have your email address and we'll send a recap this afternoon. We'll include some links to some of the lawsuit information. And again, this is not specific legal advice for any particular transaction. I very much encourage you, as Kristen does as well, to seek counsel, have your broker seek counsel if you want to add language or modify the terms of the buyer broker agreement. And I thank you guys so much for your time. I appreciate it. Welcome to the second class of Get Closed, Get Paid. Let's do both of those things.
Thank you, everyone.
All right, bye guys. Thank you.
Thank you.